Well, hello, everybody. Another Saturday at 3 p.m. coming at you. This is Zoom, Landlord-Tenant Talk Radio. We have another exciting edition every Saturday at 3 p.m. And I'm glad that there's a bunch of people already in the room waiting to get their questions answered and also to hear the tales of woe from other landlords, as we'll see. I wanted to talk about, before we start with the questions and answers, I wanted to talk about a topic that I think is going to be something positive for those landlords that have rent control property in the city of Los Angeles, those properties that are subject to something called the Rent Stabilization Ordinance in that area. We have a way right now, ladies and gentlemen, of increasing rent by 10% plus. So how are we going to do that? Well, we know that under the LA Rent Control Ordinance, we were finally allowed after 4 years to give a whopping 4% rent increase on our properties. And that was effective as of February 1st. Certainly, if you haven't done it, you need to do that now. You need to get every penny that you can possibly get. But during that time, and the pandemic started in March of 2020. And of course, the state of California, the county of Los Angeles, and specifically the city of Los Angeles created a moratorium against any kind of evictions. You couldn't evict for non-payment of rent. You actually couldn't evict if extra people moved into your property. So let's think about this logically, that here you are not getting any rent increases. You can't even evict when the tenant isn't paying the rent he was supposed to pay. This is starting from March of 2020. But in addition, these people were allowed, because there's nothing you could do with it, to bring more people into your unit. And if they brought more people into your unit, of course, it would cost you more from wear and tear on the building, more utilities, more water, and yet nothing you could do about that. Well, as of February 1st, 2024, we now can do something about that. Now, of course, we could always evict these extra people that moved into the premises in violation of the rental agreement. We've been able to do that for months. So if they brought an extra person in right now, we had the right to bring forth a demand on your tenant to get rid of these unauthorized persons, these additional people who moved into the unit. And if they didn't follow our notice, then we would have the right to evict everybody. So we've been doing those cases. But another thing that you can do, which just started as of February 1st, is if the tenancy, and I don't care whether you have a rental agreement or not, if the tenancy started, let's pretend, with 2 people, and now there's 4 people there, under the normal rules for RSO, this is pre-pandemic, you were entitled to raise the rent 10% for each additional occupant that joined after the tenancy wasn't initiated. So right now, if you had 2 people who joined the tenancy during the pandemic, you're entitled right now, today, to get a 20% rent increase in addition to the 4% that the city graciously is allowing us to do. So that would be a 24% rent increase. You'd have to serve a 90-day notice. And by serving that 90-day notice, right now, if you served it today, and quite frankly, you should be serving it immediately, as soon as this Zoom meeting is over, get yourself a change of terms of tenancy and start raising that rent. Because if you have the ability to do it, this is going to be a fleeting chance on your part to do this rent increase. Because under the rules for the city of Los Angeles, if additional persons move in, you have 60 days to raise the rent. That's from when you knew or should have known. Well, right now you had people there for years, but you couldn't do anything about it. But as of February 1st, that's when the rent increases came into effect. We now have the right to raise the rent 10% for each additional person. But let's think this out. If you've only got 60 days to do it, you're basically talking about February, March, and maybe a day or so into April. We've got to do these rent increases right now, because if you don't do the rent increase, then you lose it. So once again, if the tenancy started with one person, now there's two people there, then you have the right to raise the rent 10% plus that 4%. Now you're going to need to serve a 90-day notice, because any notice of rent increase that exceeds 10% is a 90-day notice. Otherwise, it's a 30-day notice. So there is an exception. If an additional person joined the unit and that person was a child born into the unit, that child is exempt. The second child, you are entitled to a 10%. So if they were pretty frisky during this COVID period, then you'd have the right for the second child to charge that extra 10%. Now, there's one exception to the exception. The only time you can't charge for a second child would be if they were twins. That's considered one birth, okay? So again, take a look at who moved into your unit after that tenancy was initiated. And right now, today, we're talking about RSO properties under the city of Los Angeles. Get your handy dandy rent increase out. You can get that on my website, those forms, evict123.com. They're free. And go serve that notice. And then as of June 1st, you should make it effective as of June 1st if you serve it now, and proceed forward with raising that rent to at least get you some of your money back, because these additional persons have moved in. Okay, that's my little sermon for the beginning of our Zoom meeting. We're going to open it up to questions. Remember that the information told during these meetings are for informational purposes only. It's not a substitute for legal advice. If you do want to talk, please electronically raise your hand. I'm going to try to get to as many people as I possibly can for the rest of this 1 hour. Please try to keep your questions succinct and to the point, so we can get into everybody's questions. And lastly, if you do have a case with us, a personal case with us, I don't want to discuss individual cases. Please call the office. And by the way, we're closed on Monday, so call us on Tuesday and I'll be happy to take your calls. We're going to open it up today with David. David, I'm going to ask you to unmute yourself if you'd be so kind. There you
Yes,
go.
hi. How are you?
David, I am doing good, thank you.
Okay, question is, do you have obligation to respond to a rental history inquiry from another apartment building? And if you don't answer to the written request of the rental history, is there any way you can get into trouble, or just totally ignore it?
In America, you are free to talk and you are free to shut up. So if you don't want to give any information to other landlords, you are within your rights not to say a word.
Okay, and then in regard with what you just mentioned, what if you don't have you have nothing but a oral agreement, and people bring more people inside? Is there really anything you can do, or no?
I'm so glad you mentioned that, because I should have mentioned it in our beginning talk. And that is, this is whether you have a rental agreement or not. This is like the only law that helps landlords. And trust me, there's no other law that helps landlords. Whether you have a rental agreement or not, if two people moved in, let's pretend in 1999, and now there's 4 people and they moved in during that pandemic, you have the right to increase that rent 20% additionally. So that's a good question, David.
And you have to prove it, of course, right? That they.
Well, people always say, they call me up and they say, Dennis, there's extra people there. What can we do? And I go, well, we can start an eviction. We can raise the rent. And then they always go, just like you did, well, how am I going to prove it? Well, I say, well, you called me. Why did you call me saying people are there? So what proof do I need? Do I need to have pictures? What do I need? And I go, what you need is you need two eyes. The two eyes that are in your head who can testify that, yeah, I see this guy coming and going. It's the same guy. In fact, he drives a yellow Camaro and it's parked outside. I see him walking into the house. He's using his key. He comes in the morning or leaves in the morning and comes home at night. This is all you need, just your testimony that's there. And by the way, I don't want to seem like I'm a psychic, but I'm going to guess that everybody's listening who's listening to me right now, this moment, their car is right outside, right? Wherever you are right now, your car is right outside. So people are attached to their cars. Excuse me. So if you see this person driving that yellow Camaro and that Camaro is parked overnight, guess what? He's inside the unit. So you don't have to have video. Is it good to have video? Of course, but it's not mandatory. All you need to have is two eyes in your head to say, yes, that guy's there. Anyway, good question, David. I am going to move on now to M. Broser. M. Broser, if you'd please unmute yourself.
Hi, Dennis. Thank you so much for your time. I'm planning to, I have a single family home in Somar, and I'm planning to get my tenants out because eventually I'm going to be moving back into the property. You were talking about raising the rent. I'm thinking of evicting them and giving them their 60-day notice to be out by June. Do you suggest that I still go with that rent increase or just leave it status quo?
Okay, well, first of all, in the city of Los Angeles, regardless of what type of residential unit you're talking about or when it was built, they're all subject to good cause for eviction. So you just can't serve, quote, a 60-day notice on my tenant that I want you out. You have to have a reason. So you stated that what you want to do is you want to move into the unit. Well, you certainly have the right to do that, but we have to go through an application process first with the city, and they have to approve that application. Then we have to serve on your tenant, assuming they've been there longer than 1 year, a 60-day notice to vacate, and we have to pay relocation. Relocation for a single family home where there's only one house on the lot is 1 month's rent. That's what the relocation would be. So, however, the other way to do that would be, which I don't know that you really want to do it that way, but you could just raise the rent, because if you're talking about a single family home, and I don't care what jurisdiction you're in or what rent control you're dealing with, you have the right to raise that rent. There is no limitation on rent increases for a single family home under the law. So, but I would probably just do it directly, where we go through the process with the city and we ask the tenants to move after we've filed that process and got it approved, and then pay the tenants the 1 month's rent.
Right. And I understand that there's another law coming in April that we have to, I'm looking at another law that they're going to put that we need to file before April, because a new law is just going to make it harder for the
I think what you're referring to is, this is where you're allowed to evict the tenant for renovation. In the city of Los Angeles, that law is already a little bit more restrictive than under the state law. The state law is going to be changed as of April 1st. So, but that's only if you want to do a renovation of the unit. You don't want to move in, you just want to renovate the unit. Then you would have the right to ask the tenant to leave, pay 1 month's rent, but they do make it a little bit more difficult. But again, that's not your situation.
Right,
It doesn't
right,
affect you. Yours is dealing with the fact that you want to move in.
right.
any
Thank
event,
you so much.
You take care, sir. And now we're going to move on to Matthew Zarabi. Matthew Zarabi, I'm going to ask you to unmute yourself.
Yes, how are you? Can you hear me?
I hear you wonderfully, sir.
Thank you for taking my question, Dennis. I'll try to make it short. I recently acquired a building January 31st this year. I've encountered several issues regarding the tenancy and the lease agreements. Firstly, a significant number of tenants for the February rent payments were made by individuals not on the lease agreements. Furthermore, it come to my attention that the actual occupants in some of the apartments either exceed the number listed on the lease agreement and in some cases are not the original leasee, but are instead subletting. The property is a non-RSO located in LA City. I'm concerned about the legality of depositing the rent checks because they're from individuals not on the lease. And I've heard that accepting rents can inadvertently establish tenancy that can complicate it. It's possible that the previous owner accepted rents from these parties. And given these complexities, should I refrain from depositing the checks until this matter is resolved? What legal actions can be taken to address the issue of unauthorized occupants and subletting? Thank you for your time.
No problem. Very succinct.
Sorry.
The problem is that you're the new owner of the property. And
Yes.
as you indicated, that we don't know if the previous owner had been accepting rent from these strangers. And if he did, then he unfortunately created a tenancy with these strangers by accepting their rent. Is there any way that you can go back to either the previous manager or to the previous owner and say, wait a second, who's giving me all these strange rents? It doesn't match what's on the rental agreement. And also, did you get an estoppel when you bought the building from each of your tenants?
I got some estoppels. I suspect that they were paying the previous tenant, the previous landlord. I can confirm that later. I can find out. But keep in mind, it's a non-RSO. Does that make a difference? Does it still establish tenancy even if it's non-RSO?
Yes, it still would establish tenancy, but if it's non-RSO, I presume it was built more than 15 years ago, correct?
Yes, 1986.
So on that basis, you're under what they call state law. You can raise the rent 8.8%. Now, I don't know if that's going to make you feel warm and fuzzy, but you know, if you're getting rent from strangers, I would go over to them and say, listen, this is not the name on the rental agreement. And who are you before I accept your rent? So I would have discussions with them. However, since you can raise the rent 8.8%, that might just make it worthwhile for you that you don't want to change the occupants if they're paying the rent. Would that make you happy with regard to that you're getting in enough revenue? Does that get it close to market value? Are we still there? Wait, help, I think I lost you. I'm going to ask you to unmute yourself.
Sorry about that. Can you repeat that one more time?
Sure.
I would want to increase the rents. There are many additional occupants other than the original leaseholders that are residing in the units.
Okay, so I think you can, hopefully, especially if these rental agreements started in March of 2020, or at least these people moved in after March of 2020. If they did, the strangers I'm referring to, then in that situation, you can raise the rent 10% for each additional person. So let's pretend you have a rental agreement that was, let's say in March of 2020, and it said who was living on it. Then you know if there's more people there, you can get a 10% rent increase for each.
But if it was prior to 2020 and they've been
see, then you don't know if these strangers moved in. Let's pretend the strangers moved in December of 2019. Then you would have lost your right to ask for it because you only got 60 days. Right now, we're in a window because they refused to allow us to raise the rent for the last 3.5, 4 years. Now our window started, the 60-day period started as of February 1.
Yeah, I wasn't sure if the 60-day benchmark was just for RSO, but I guess it's also for just the regular non-RSO.
No, actually, the 10%, I take it back. The 10% is only for RSO properties. You might have a phrase in your rental agreement, though, and most of them do, that if an additional person moves in, I'm entitled to $100. So take a look.
No, it actually says 25% or the legal maximum of rent control law. That's what it says on the leases.
Okay, so I would say that you can go that amount. So first, I think you need to have a conversation with these tenants and find out who they are and whether the original tenant is still there or not.
Yes.
And then proceed on that basis to, you can certainly raise the rent. The issue is going to be by how much. So, and also you might be able to also use the issue of that, hey, you're violating the rental agreement. And so I'm going to serve you with a notice to perform or quit to get rid of this unauthorized person. And if not, then I'll go forward with with an eviction, just change out that unit. So you've got yourself some options, but I would, in this situation, first have a conversation, and you might want to call our office.
Yes, I talked to Suzanne. I'm definitely gonna hire you guys. You're the best.
All right, thank you, sir. Appreciate it. And we're going to move on to Kara. Kara, come on down and by unmuting yourself. Kara, are you there? Okay, Kara, we gave you a chance. I might come back to you. Let's go to Derek. Derek, if you could unmute yourself. Hello, Derek.
How are you?
I am good, thank you.
Long time no talk. I hope you're well.
I am, thank you.
Yeah. I'm a realtor with EXP. I sell apartment buildings, if you remember, Dennis. And we're going through an Ellis Act on one of my listings.
Well, before we go on with that, which office are you at?
I'm with EXP Realty here in Los Angeles.
Yeah, and what's their phone number? How can they get in touch with you?
310-308-3174, and I specialize in Los Angeles apartment building sales.
Sounds great. And by the way, you don't have to write that down, ladies and gentlemen, because if you come back to my website, you'll get I'll have it listed. You know, we make the YouTube as part of our telecast after the show, so you can get the number from them. But go ahead,
Okay,
Derek.
So I have a rent control duplex in Venice Beach. It's the sellers started the Ellis Act to serve the tenants on September 1st, 2023. And they proceeded to list the property. The reason they wanted to do that, they got a really big problem tenant, and we want to sell to a developer. And this developer wants to, knock down the property. Of course, they can't have tenants in when they close escrow. So I'm sure you're very familiar with the Ellis Act, correct?
We are.
Okay. The previous attorney for the tenant said that the problem tenant would be willing to relocate early for a significant cash buyout. Okay. So me and the tenant negotiated a price and a date for her to move. Okay. The attorney said, it's okay, talk to her, no problem. In January, her lawyer left, just said, I'm not going to take this case, I'm retiring. She got a new lawyer, and this guy's a real piece of work. And he said that the Ellis Act is invalid because my client didn't properly create the escrow account with her name on it, with the money that has to go in there, $24,000.
Once you get the authorization from the city to go through an Ellis Act eviction, you serve a 120-day notice. And then within 15 days, you either have to give the relocation money or you have to set up an escrow account. If that wasn't done, then you're going to have to restart it all over again. But again, he's asking for a substantial amount of money. Why pay him anything? You're just going to go through an Ellis Act. And then at that situation, they're going to get just what the law requires, which the maximum is only at $24,900 and some odd dollars.
Yeah, that's what she's entitled to. So what he did is he set up a bank account at Chase, but it wasn't an escrow account. It was a bank account. And then the attorney said, hey, there's no escrow account with her name on it. So me and the seller were like, oh. So we went out and we found an escrow company to open an account and put the money in there with her name on it. But he's claiming that it's invalidated the whole Ellis Act.
I'm in agreement with them. They're very procedural. And if you didn't do that, you're going to need to start it all over again. So, but it's not that big of a deal to restart it all over again. We file them with the city, and then we have to have a meeting with the city. But usually we get approval within about 30 to 45 days. Then we'll serve again. the 120-day notice, and then you'll open up that escrow account immediately, or you can actually just give them the money.
Okay, well, the reason why we wanted to get it done quicker is because we have a cash offer on the table that we know wants to close, and my sellers want to sell. It's a fabulous offer,
Well,
and obviously they'd rather pay her some money to leave early versus having to start this whole thing over again.
and I'm not disagreeing with that, assuming it makes sense to do so. But otherwise, if the purchaser of the building is the one who is going to really do the demolition of the building and reconfigure the premises to a new structure, that's the person who should be doing the Ellis Act eviction, not somebody just selling the property.
Well, the thing is, this is hard to believe. This buyer for the property used to own the property next door to my listing, and he's in a lawsuit with this tenant over noise nuisance. So he wants nothing to do with her. He's not going to buy the property until she's out. So,
Well, you have the right to, whether you're doing the construction or not, you have the right to permanently take that unit off of rental housing use. So on that basis, you should call our office or restart the procedures. In my office, it's Jennifer Hartman is our Ellis Act specialist, as you might know, and so she'll run down all the details with you. But it looks like, based on what you're telling me, that you're going to have to restart it all over again. But again, it's not that big of a deal. But I mean, that's your options. If he doesn't want to take the deal unless this tenant's out, then you've got to comply with the Ellis Act, and it doesn't appear that you did.
yeah, just to wrap up the story, my client does have an attorney. It's his cousin, but his cousin doesn't know rent control like you guys do and stuff. And I told my client, I said, look, man, I'm going to go talk to Dennis Block on his show on Saturday. Let's hire his firm to restart everything and make sure we have the right attorney on the case.
Yeah, they're very procedural, just like even a non-payment of rent case now in Los Angeles is very procedural. And these rules are designed for landlords to fall on their face. Anyway, thank you very much, Derek. We're going to move on to, let's move on to, next one online here is Arden. Arden, I'm going to ask you to unmute yourself, please. Hello,
Hi,
Arden.
Dennis. Hi, thank you for taking my question. I have a non-RSO property in the city of Los Angeles, and I just wanted to know if I serve my tenants with a change in terms of tenancy, requiring them to carry renter's insurance, would that be considered a rent increase?
No, it's not considered a rent increase. You can't change, you can change the terms of the tenancy to require that they may require renter's insurance. But the reason why you're doing that is not for them to carry renter's insurance. The reason why you're doing that is for them not to come back at you. So I have a wonderful form on my website, evict123.com, in the free form section, and it's called renter's insurance, that particular form. And it starts with tenant may or must obtain renter's insurance. But what it goes on to state is that if anything bad happens and your personal property is damaged, you can't go after me. You can only go after your insurance company. Secondly, it says that if for whatever reason you have to relocate, then it's on your dime to pay for any hotels or out-of-pocket expenses. So definitely, Arden, use that form, and it is not a violation of rent control.
Okay, and so can I require that they obtain renter's insurance via change in terms of tenancy, or is that not allowed?
Well, whether you require it or not, there was a case that came down many years ago that says you can't evict for not having it, even if you have that as in your rental agreement from the initiation of the tenancy. So it doesn't matter which box you check. The only reason why you're doing this is that someone doesn't come back and try to sue you.
Well, so in this particular instance, they made an alteration and installed a bidet that caused water damage. And so there's policies out there that cover tenant water damage to the landlord's property. And so I'm wondering if, as a condition for that alteration being permitted, I could require renter's insurance.
You can require it, but again, you can't evict based on the fact that they didn't acquire it. But if a tenant did an alteration and that alteration caused damage, the tenant's responsible. So you can sue the tenant and or evict the tenant based on that damage that they created.
Got it. Okay. Thank you.
Thank you. And let's move on to, looks like a return visitor. Let's move on to Leonard. Leonard, how are you today?
Hey, good, Dennis. Yes, I have a case with you, but I'm not discussing that. The only question I have is on the last page of the unlawful tainer, there's a court hearing date. Does that mean that they issue the tenants that an advanced court hearing
Okay,
date?
let me, do not get worried, because that date usually is way in the future. That's just every time you file an unlawful detainer, the court sets up a status conference way in the future. And what that date is, it's saying to everybody, look, we don't want you just to file a lawsuit and sit on it. We want you to move these cases along. So we're going to have a date sometime in the future that you're going to, if you haven't finished this case, then you're going to need to come to court and explain why you're just sitting on this case and not really prosecuting it. So that's all that is, Leonard.
So in other words, the date could be
The date
advanced.
means nothing, and it's never going to happen in most lawsuits.
Okay, and then the second question is, I never heard of your results of your case. What happened with that, with your court action?
The
Your
jury
personal.
ruled against us. However, they did it with a big error. So I have a hearing now coming up on March 18th. And on that hearing, keep your fingers crossed. I think we're going to win the whole thing. March 18th.
I was just wondering. Thank you.
Thank you, Leonard. So let's move on to Fernando. Fernando, I'm going to ask you to unmute yourself. Hello.
Hello, good afternoon.
Hi.
Hi. Good afternoon. The question we have is, can we evict a tenant who does not have a rental agreement and who also brought in dogs? My father rented to tenants, and when I asked him for the paperwork, all he could give me was a rental application. So I don't think we have a rental agreement with this tenant.
Well, did you just recently buy this property? Is that what happened?
No, my father's owned it for over 30 years, and this tenant has been there for a number of years. And it was only recently that I got curious, and I asked my dad to show me all the paperwork that he has, because we're having issues with this particular tenant.
Okay, but then wouldn't your father have a copy of the rental agreement, assuming there was one?
My dad is very old school and does a lot of oral agreements, which is part of the reason we're coming up on these issues.
Okay, and what city is this?
Southgate.
Southgate. Okay, and this is an apartment house?
It's a 1 unit in a three unit building.
Okay, so it's a triplex. So
yeah,
in that situation, your father probably didn't rent it with a rental agreement. You can ask the tenant for a copy, but if the tenant says no, then there's really nothing that you can do. So this tenant is there on an oral agreement. If he doesn't pay the rent, obviously you can evict. If he brings in animals, then there's nothing you can do with that unless it would violate some city law. I know the city of Los Angeles, I think you're allowed maybe 3 or 4 dogs tops, but that's what you have. Now, of course, you can raise the rent 8.8%, because for Southgate, you're under statewide rent control. Another thing that you can do if you wanted to get rid of the tenant would be to do a renovation to the unit, as we discussed. And that's, and I'm sure if the tenant's been there for a long time, it might make sense to do that. Renovation is described as work that will render the premises uninhabitable for at least 30 days and will require that the landlord get a building permit. So bottom line is, if you're going to redo the kitchen and the bathroom, it's going to take longer than 30 days, and you're going to have to pull an electrical or a plumbing permit. So if you want to use that as a reason, we could evict the tenants. You don't have to hire a contractor now or pull the permits now for Southgate. We can first evict the tenant, but once the tenant's gone, you're going to need to make sure that work takes longer than 30 days and renders it uninhabitable, and make sure that your contractor gets a building permit to prove that the work was done with a permit, so you're in compliance with the law. So that might be just an easy way to get rid of this tenant if that's what you want to do. And by the way, You'll improve the premises, and you'll also get a bunch more rent once these tenants leave.
If I want to raise the rent, do I just serve them a notice that the rent's going to be raised?
Yes, it would be 8.8%. Serve a 30-day notice. If you serve it in the next few days, make sure it's effective as of April 1st. Just mail
Excellent.
it to
Thank you
them.
very much.
You take care, sir. Okay, let's move on. I see Mark P. Mark P wants to talk to me. What do you have to say, Mark?
Yeah, good afternoon, Dennis. Thank you. Two questions. One is we've got a vacant unit that we've been showing. Some of the prospects are getting very aggressive in terms of pushing. If they have bad credit, they're saying there's a new law that passed saying that we cannot take that into account if they have Section 8 or, you know, some other assisted. And then I have a second question after that.
Good. I like doing them one at a time. I don't know about your particular applicants, but there is a law dealing with Section 8 only, not any other governmental assistance, but Section 8, you can't just reject a Section 8 applicant based on bad credit. You have to take into account their ability to pay, So if under Section 8 for this $2,500 apartment, they only have to pay $300, they'll have to show you that they have the ability to pay at least $300 per month, that they have the wherewithal to do so. And you can't just go on their, you just can't go on their credit history. It's an insane law. However, I've been preaching that the way to get around taking Section 8 is change all of your policies for all of your buildings and make it that you only rent pursuant to a month-to-month rental agreement. You will no longer do a one-year lease. Section 8 will not accept month-to-month tenancies. You have to lease it for at least a one-year period. So your position is, I would love to rent to these people. I'm dying for them to come into my building. The rent that they're offering is fine. I don't care that their credit is in the toilet. But I'm only renting on a month-to-month basis. So, you know, if the Section 8 wants to accept you, we're happy to have you come in. But I think by doing that, it's not going to happen.
Okay, it's still legal to require a positive landlord reference, like a good rental history, correct? Even with this new law?
You can ask for references. I don't see any problem with that, as long as your policies are consistent, that you're not just doing it for Section 8 tenancies. So I would like, you know, some references from your previous landlord.
Okay, second question, a tenant passed away. How do we handle the security deposit, accounting, and refund?
Did the tenant give you 30 days notice that they were going to vacate?
No, not in this case.
All right, that's a little bit of eviction humor. Okay, so how do you handle it? Well, you still have to, within 21 days from the tenant vacating the unit, even though he vacated horizontally, you do have to account for the security deposit. Do you know any relatives, like a child or something?
Yeah, his sister has come into town from Vegas and she's handled his funeral arrangements.
All right, then I would make the check payable to her as the closest relative and let her sign a statement saying that I am entitled to as the closest living relative.
Okay, thank you, Dennis. Appreciate it.
Always nice talking to you, Mark. Okay, we're going to move on to Dev Chakrabi. I know I just butchered your name, but Dev, say hello, please, by unmuting yourself.
Hello, Dennis. It's
Hello.
okay. I've had it butchered before, but
I would think so.
hey, I'm a new owner for a unit in Valley Village, and
Sorry about that.
tenant hasn't paid in February, and I closed on the 4th. So then they I think the escrow prorated me that, but he hasn't paid, and I don't think he's gonna pay in March. So can I start the eviction process like March 2nd?
When did you purchase the premises?
I closed I think I closed or on the recorded February 6th.
Okay, so since you didn't own the property on February 1st,
Mhm.
you are not entitled to the rent nor even a proration of the rent.
Okay.
However, as of March 1st, the tenant will now owe you the rent. You want to make sure
Mhm.
that you sent an ownership letter to your tenant. This ownership letter has to state that I am the new owner. This is a physical address, not a PO box, but a physical address where you can serve me with notices and legal process. You have
Mhm.
to have your phone number on that. You have to have the times when they can contact you, like Monday through Saturday, 9 to 6. And
Mhm.
also you need to state how the rent is to be paid. Do you
Mhm.
want it paid to a bank account? You can have it paid to a PO box.
Mhm.
You can have it paid to a rent collection box or your physical address. But you have to have that in. Otherwise, you're not entitled to the March's rent. So March 1 comes out to be on a Friday. So on Saturday, if you don't get your rent on the 1st, you can actually go over there on Saturday or Sunday, serve a 3-day notice to pay rent,
Mhm.
and then the tenant would have till Wednesday midnight to
Mhm.
pay you, and then we can commence the lawsuit. But you do know under the city of Los Angeles that number one, the unit has to be registered. A copy of the registration certificate that you get each year has to be given to the tenant. And there also has to be signs posted on the property. One is called an RSO notice that this property is subject to the RSO. And also there's another one, which is a 2-page form called the Eviction Protection Act. So that has to be also posted on the property. So get all your ducks in a line with
Mhm.
regard to that. Those forms are on my website, or you can get them from LAHD, standing for the Los Angeles Housing Department.
And if we go with your firm, do you guys handle all that or?
Yeah, we take, except for the registration certificate,
Right.
which you should go down to an LAHD and say, hey, I'm the new owner. Here's my closing statement, or here's my deed.
Okay.
And, but we'll take care of doing everything else.
Okay. And is there a rule? I remember, so the rent he owes or his monthly rent's 1,800. Does it have to be over $2,000 to start this, or I could start it as soon as he doesn't pay
Great,
March?
great question. How many bedrooms?
It's a 4 unit complex.
How many
4 unit.
bedrooms for his unit?
Oh, 1 bedroom.
It's 2006, my good friend. So everything I just said was thrown out the window. You have to have a 3-day notice that includes more than $2,006. So you're going to have to actually wait till April.
Till April. Okay.
Yep, sorry about that. But that's your
Okay.
city council at work.
Okay. Gotcha.
All right. Anyway, thanks. Good luck with the building.
Thank you.
My office building used to be, actually, I still have the building, but we used to be in Valley Village on Laurel Canyon.
I'm on
And-
Riverside Drive, right by like the Mikado Hotel.
Oh, yes, of course.
Yeah, so it's my first investment into fourplex, but I'm learning quite a bit.
Well, stay tuned to this.
Yeah.
And you'll learn you'll learn all the issues.
Thanks.
All right. You take care, sir.
Take care.
Okay, and let's move on to, it looks like I got a pair here. Let's go to Jordan and Adriana. Say hello. Please, there you go.
Thanks for having us today.
No problem.
So I have a tenant who's on a periodic tenancy. She started on a 3-month lease now. It's just been month to month. We have not hit the year mark, but I need her out because she's always bothering the Airbnb guests next door, also my unit.
Okay, so first of all, what city?
It's LA City.
Okay, she's been there more than 6 months?
She has.
Okay, and this building was built prior to 1979 or after?
Prior.
Okay, so you're under RSO, so it doesn't matter how long she's there. You can't just evict the tenant unless you have good cause. You say she's bothering the Airbnb. Is it your Airbnb tenants?
It is, and I did include a provision in the lease that she's not to disturb the Airbnb guests.
Well, you're not allowed to disturb anybody. So whether they're Airbnb, just to let you know that what you're doing, renting that out, is not in accordance with the law for the city of Los Angeles. It's called home sharing. You have to have a license, and if you can't, if you own the building, you have to be in that unit for, I think, like 2/3 of the year. So technically having Airbnb guests there is not proper. I mean, everybody does it, but it's not proper. But the problem with her bothering the Airbnb people, first of all, you didn't tell me, how is she bothering them?
So there's a broken air conditioner on the roof, and she keeps running it, and it's vibrating over their bedrooms. And she said she would get a portable AC and use that, but she continues to use the one on the roof. And I keep getting messages through Airbnb, hey, we can't sleep. This air conditioning above our bedroom's running.
But my good friend, it's your building. Why don't you just fix that air conditioner?
Oh, I actually did give her notice to send the repairman, and she refused him
And how did she refuse him?
via text. Hey, that time's not going to work for me.
Okay, so I think you're creating your own problems, my good friend. So
Okay.
first of all, it doesn't matter what she says. When you serve an access notice, as long as you're doing it Monday through Friday, 9 to 5, and you have a reason to go in, then doesn't matter what they say, you just go in and get this air conditioner fixed. That seems like the easiest way to solve your problem so your Airbnb guests aren't disturbed. So she's not really creating a nuisance. She's just turning on the air conditioner, and that's creating a problem. But who's responsible for a noisy air conditioner? And I would take a wild guess and say a person by the name of Jordan and Adriana. So go get the damn thing fixed, and that'll solve your problem there. But be careful with regard to your Airbnb revenue stream, because that could be taken away from you.
Yeah. Okay. And what do you mean by that? I do have a license, the permit for it.
You do have a license to be an Airbnb?
Yes.
Okay, but it says that you're supposed to be in that unit most of the time, and I don't think you are. So go check the requirements on that. So
Okay. Well, thank you for your help today.
no problem. Nice talking with you, and good luck. Okay, let's move on to, look at this, we got a doctor in the house. Dr. Amadi, please unmute yourself and say hello.
Yes, hello, Mr. Dennis, and thank you for your time.
No problem.
Recently bought a complex in Southgate, and that needs renovation. And most of the tenants are out, but one of them is asking to stay and pay about $1,000 more than what he is paying rent. Is that legal for me to accept that?
I just want to ask first, as a doctor, do you know anything about vertigo?
Yeah. Well, I'm a dentist actually, but I know what vertigo is.
Well, good, because right now I think I'm getting dizzy here based on the way you're holding the camera. But notwithstanding that, no, the tenant can't stay and pay $1,000 more. You could move them into a different unit. And if you do, after you renovate it, move him into a different unit, but he can't stay in the same unit. So he'd have to move out, be out for 30 days. And I don't recommend renting that same unit back to him. That could just be troublesome. So I would decline that offer, but tell him he could take another unit in the building.
Okay, thank you so much.
All right, you take care.
You too. Bye-bye.
Okay, I'm going to ask you, there you go. There we go. Okay, let's move on to Maria Gonzalez. I'm going to ask you to unmute yourself.
Yes. Hi, Dennis.
Hello.
My first time here. I have two quick questions. The first one is, I don't have keys to the unit. I need to make repairs. Tenant is being a little difficult, so I can get his keys to get copies. Do I serve him a 24-hour notice to enter the unit? Do I check the box where it says repairs? And then what I will be doing will be taking a locksmith to change the lock so I could get my own set of keys and then give him his set.
How is it that you don't have a set of keys?
I've always relied on just texting and letting him know when a repairman will go over, and he would always just be there. But lately, because we're in a little conflict, he's being a little difficult, and I've just tried to just get keys from him so I could just make my own set of keys.
Okay, but when when you leased the property to him, didn't you keep a key?
No, he was an existing tenant.
Okay, so on the notice that you're gonna serve him, also put on that, I'm gonna be making a key for myself and I will leave you duplicate keys. I don't see any problem with that.
Okay. Next question, the roof is gonna be replaced, so a new roof. What type of notice do I give them, or if any notice that I need to give them because of or they're gonna start early, the noise and all that?
I would just, it doesn't have to be, just be a friendly letter that, hey, we're improving the building by putting on a new roof so that we don't have any problems with these storms that keep coming. And
Okay.
just to let you know, but you know, obviously the law requires that construction can go on in a building, and there's specific hours that it can go. It can't go into 10 p.m. in the evening. So I'm sure
Right.
your contractor is going to be aware of those laws and do the construction during those hours. But yeah, I don't think it's bad to give a courtesy notice to your tenants as to what's going on. The roofer's not going to go into their unit, so there's no issue
No.
there.
Yeah. Okay. Thank you so much.
Nice talking with you. And we're going to move on to see how many we can get through here. Pablo, please unmute and say hello.
Good afternoon, Dennis. Thanks for taking my question. I have a two-part question. One, I have a single-family home in Los Angeles. How do I confirm that I am not in a rent-controlled area?
Well, you are in a rent control area, but the issue is with regard to if it's a single family home and only one house on the lot.
That's correct.
Okay, so you can raise the rent to whatever you like. If you go above 10%, you need to serve a 90-day notice. If it's 10% or less, it's a 30-day notice. Now, under the new rules for the city of Los Angeles, your single family residence is subject to just cause evictions. In other words, you just can't ask the tenant to move. You'd have to have a permissible reason. And as I mentioned earlier in the show, that would not be where you want to sell the property. But again, you can raise the rent to whatever you like. Now, there is a form that needs to be posted on the property, which is the Tenant Protection Act. That needs to be posted on the property, even if it's a single family residence. If the tenants tear it down, then they tear it down, but this is what the law requires.
Great, brilliant. And you inadvertently answered my second question, is how much notice do I need to give pending how much amount of rent, additional rent increase? And as I understand
Exactly.
it, yeah, okay.
All right, nice talking to you. And let's move on to, I see, looks like Vic SP. Vic SP, I'm going to ask you to unmute yourself.
Hello, Dennis. It's Victor.
Hi.
Dennis, I purchased a property a year ago in April 2023 in 5 units in Southgate. And I immediately got them to sign the lease agreement that's under on your website.
Mm-hmm.
Thank you very much. And at the same time, I also gave them the rent increase effective June that same year, of course. A couple months later, I just found out that, or a few months ago, I found out that there's 2 additional people living there at the property. So my question is, and looking at your lease agreement states that I can raise it $100 per person.
Right.
And so I'm thinking about doing that. So it's just 2 people. If I could do the $200 increase effective, I want to see if I can make it effective April of 2023. And then the other question would be is, can I still raise the rent in June of 2024? I'm sorry.
Okay, well,
I'm
first
not
of
raising
all,
the rent I don't feel I'm raising the rent because of I don't know. That's why I'm confused.
right, you're under a statewide rent control. Under statewide rent control, they don't have a provision where you can raise the rent an additional amount if an extra person moves in. So you're kind of in a gray area of the law. Your position, if I was arguing on your side, would be that, look, we're not raising the rent. The rent was always going to be $100 more if an extra person moved in. But under the state law, they could say, look, this is what you're allowed right now, 8.8%. So it's a wobbler in that situation, whether you can or you can't. do that. And so, and there hasn't been any decisions by any court to allow that. So whether it's been decided yet or not by any appeals court. So you're kind of on your own whether you do that. I mean, my position again would be, hey, look, we're not raising the rent. The rent was always the rent plus 10% if somebody else came in. So that's not a rent increase. So got to take your chances, my friend.
That's a toughie then, because
Yes.
yeah, 'cause looking at your lease agreements telling me that I could do the 100 and they signed
Right.
it.
But if my lease agreement said you could commit a murder, the law would be above us, right?
Yeah.
So this is, if it was a non-rent controlled area, that would be great, but this is
It's in
under
Southgate.
statewide rent control.
Oh, that's right, statewide.
So, and under statewide rent control, there really is no provision to do that. So we would have to fall back on my argument that, hey, this isn't a rent increase. This is just, you always agreed that the rent would be this much if in fact you brought in extra people. Of course, you have the right to evict for unauthorized persons. That's always there. But it's an interesting issue. In any event, we're going to try to get in a couple more people here. So I appreciate the question. Let's move over to Emma, and then I'm going to hit Victor, who's really needs to be talked to. So Emma, I'm going to ask you to unmute yourself, please. Thank you.
Hi, Mr. Block. Thank you for taking my call.
No problem.
My question has to do with this 2-bedroom apartment in Van Nuys, non-RSO. I purchased it from my brother around August of last year. And I inherited a tenant that has not paid rent, like the old COVID rent, a little over $23,000. And he is current right now, but it appears that he's waiting to get paid, I guess, cash for the apartment for $40,000 plus. He's not making any attempts to contribute towards that old rent. So I'm trying to figure out what would be the best route for me to get my apartment back. Granted that his current rents are pretty low, I could definitely get an additional $500 if I had the vacancy.
Under the law, you're allowed to right now, as of February 1st, go back and ask for all the rent that's owed. If it's rent owed from March 1st, 2020 through September 30th, 2021, we can serve them with a 15-day notice and proceed forward with an eviction. And right now, this second, if it's rent owed from October 1st, 2021 through January of 2023, it would only be a 3-day notice. So we can actually go back right now and do an eviction based on that rent. Now, but there's one exception which might hurt you. You say you bought the property from your brother?
Yes.
And so now, and obviously the tenant knows that you're the new owner, correct?
He knows that my LLC is the new owner, but he doesn't know that there's a relationship, or at least that I'm aware of.
The problem is when there's a change of ownership, the new owner can't evict for old rent. That's the problem. Like I told that one person who bought the building in February, I said, we'll have to wait till the March's rent. So if the tenant is smart and knows that, hey, you didn't own the building back then, and if there's a change of ownership, the only thing that can happen would be you can bring forth a civil lawsuit for that, but you can't actually do an eviction. So that might be the exception in your situation, since when he owed that rent, you weren't the owner.
Okay, because I had both scenarios. Somebody, an attorney, told me that I inherited the debt, and I could, but I think you're right. I think it's in the small claims, right? A small claims court.
Yeah, you can do a small claims court for that as well.
I'm not sure how that's going to help me though.
No, I don't think so. We might just want to change it. Very few people know this law, that a new owner can't, even if the rent is assigned to the new owner, can't use that old rent as a cause to evict. but very few people know that. I know it, but I don't know who else does. Anyway, thank you very much. I'm going to move on to Victor. Hello, Victor. Wait. I got to get to Victor. Victor, please ask. I'm going to ask you to unmute yourself.
Hello, Dennis. How are you?
I am fine, sir.
Thank you for taking my call. I have a tenant in a one-bedroom house in Los Angeles. He's 7 months into a one-year lease. There is a phrase in the lease that says the lease will convert to month upon approval of the landlord, upon written approval of the landlord at the completion of 1 year. He's advised me he is entitled to reduce his rent by $580 for breach of his, quote, implied right to quiet enjoyment during recent flood and water damage repairs to the adjacent building, which involved tearing out walls and replacing ruined plaster and replacing a drain underneath his house to prevent, because there was water damage from a broken pipe in his broken drain in his house. So
just out of curiosity, was there a problem with your building or the building next door?
I own all three.
Okay.
There are two storefronts, and there's a house behind it that's attached to the back of the two storefronts. So it's not really a triplex. They're all separate addresses. So I guess I want to know what I do if he offers me, if he pays me a reduced rent.
Well, you're not going to accept it, number one.
If it comes by Venmo, I send it back and say it's an unauthorized deposit.
No, you'll say, well, I don't accept partial payments and you owe me every single penny, and tell him that you talked to Dennis Block and Dennis Block told me to tell you to stop drinking Kool-Aid.
Okay.
The guy's out of his mind. Listen, things are going to go wrong with an apartment. That doesn't mean that all of a sudden the tenant gets to reduce the rent. It means that the landlord with due diligence is supposed to fix the damn place.
Okay. I think that I should limit my question to that answer. I don't want to take one more call. Thank you so much for taking my call, sir.
Okay, we are at the end of our time, but I'm still going to pick on Missy because she's been very patient, and then we'll pick it up next week. So Missy, I'm going to ask you to unmute yourself. Missy A, where are you, girl? Okay, I'm going to take one more call. I'm going to go MK. MK, please unmute yourself.
Hi, Dennis. Thank you for taking my call.
No problem.
I have a question. I just found out that my tenant is growing marijuana. He said that it's for personal use, but it doesn't sound like it. The way I found it was the neighbor contacted me a few days ago, and he said the police was at my house, and basically they were arresting them. And I texted the tenant and asked him what's going on, and he said that yes, he was growing marijuana and he was cited for the violation 104.15. So my question is, what are my responsibilities as a landlord?
Well, first of all, this is a single family home?
Yes.
Only one house on the lot?
Yes.
Your tenant's right in one small aspect, that you are allowed to grow marijuana for your personal use, which is no more than 6 mature plants. However, obviously, if the police raided it, he has a grow house in there. So he's committed a crime on your property. I think what you should immediately do is commence an eviction to get rid of the person.
Okay. So, okay. He has 3 months into his lease, and I was going to do an inspection. So you don't recommend me to do that?
Well, I would certainly do an inspection. You want to see what your property looks like. But the bottom line is that the guy's growing marijuana in your place. You got to get rid of this guy. Okay.
Are they able to cite me also for this violation?
They can, and they can, and they do. Like if a landlord rents to somebody who says, I'm just going to be selling cigarettes, and all of a sudden they start selling marijuana without a license, then the city attorney goes after them. So you're the landlord, they're going to go after you. This is not a good situation. You need to get rid of these people. Anyway, thank you so much. I'm going to call it a day. I want to thank everybody for joining us. If you do watch us on YouTube on my channel, which you can get from my website, evict123.com, please subscribe because it does help defray a little bit of the costs. I'm going to be doing this, as you know, every Saturday. So we had a incredible amount of people in both on YouTube and on the Zoom meeting. So I'm very, very happy that we get to have this meeting once a week. Hopefully you guys find it interesting. And I'm going to sign off. Thank you so much. By the way, in case anybody was questioning, the song of the day was Everywhere by Fleetwood Mac. I wanted to get that in. I always like that song. And everybody take care. Have a great weekend. And it's an extended weekend because the old man's office is closed on Monday for President's Day. You guys take care.